Mr. Whitmire, in cause number 25, DCCR 0057, you're charged with a second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement, and clause number 25, DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I going to have to start? And this is cause number 25, DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26, DCCR 0385, charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed it.
Is the offer, let's see.
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
Right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be, they try that and then you could turn around and try the next one as well.
Yes, Judge. We'd be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent.
Well, it would be up to me. So it depends on if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question. It's a court question. Okay. The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right. We'll get it set for trial. Then you can go back with the bailiff. Good morning. Are you Joseph Roberts?
Yes, ma'am. Good morning.
Good morning. This is 20-34226. Mr. Roberts, looks like you were on probation for the felony offense of driving while intoxicated, and that you were placed on probation November 30th of 2020. That was a 7-year term in prison that was probated for 7 years. Some of the allegations, it looks like there is an additional driving while intoxicated charge from April 26th of 2026. Curfew issue, operating a vehicle without an ignition interlock device, and then some minor fees. Mr. Nix has filed a motion asking that I set bond in your cases. Currently, there is no bond. He's also handed me, it looks like there was a 30-day treatment at Level Up Treatment, Texas, that you went to April 26th through May 29th of this year. Mr. Roberts, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Mr. Nix?
Your Honor, we'd ask that the court set a reasonable bond. My client's willing to forfeit his right to drive. He would wear a scram device, comply with any curfew set by the court. As the court can see, he did not have any issues on the probation for several years until he picked up this new offense. It was not his vehicle. There were several other occupants in the vehicle, which would explain why he wasn't complying with the interlock device. He obviously knows that he made a pretty terrible mistake, and if the court will acknowledge, just 3 days after his arrest, he voluntarily did a month of inpatient rehabilitation. Also, I'd like the court to take knowledge of, and although I didn't put it in my motion, I think we've made the court aware with the district attorney. His daughter was brutally murdered about 10 days ago now, somewhere around there.
This is the moment the entire courtroom changes. The discussion is no longer just about probation violations or DWI allegations. It's suddenly about grief, loss, and whether someone deserves one final chance.
2 weeks. About 2 weeks ago, her daughter's his daughter's funeral is this Saturday. She was the victim of one of our homicides here in Beaumont out of a domestic violence situation with what appears to be a boyfriend or ex-boyfriend. He'd like to, be obviously on bail so that he can attend his daughter's funeral. He would adhere to any recommendations, anything that the court requires of him of his bond. He's also just been accepted into an IOP program where he will be doing counseling therapy for alcohol, substance abuse.
From a legal standpoint, personal tragedy doesn't erase criminal allegations, but judges often consider rehabilitation efforts and life circumstances when deciding bond conditions.
As part of that program, they do random alcohol and drug tests. This is something that his insurance offered him after finding out about his daughter. So not exactly related to the DWI, but it's related to finding out that his daughter was murdered in the way she was murdered. He's taking advantage of that. Obviously, he doesn't want to have an episode where he falls off given what his family's going through. He is not the sole provider of his family, but he is the main provider of his family. They have 2 homes, one home that they live in, another home that they haven't been able to sell. So they have 2 mortgages to pay for and bills. Is that correct, Mr.
Yes, sir.
And right now I'd ask if Mr. Roberts can give more details to the IOP than I might be able to. Can you explain to the judge?
What's the name of it, or where is it? What's it through?
It's Trust Health.
Trust.
Trust. TROST.
Trust.
Yes, ma'am. We do 3-hour sessions, 3 days a week.
Is it on?
That's a group.
Is it
I
online?
do it virtual. I do virtual. Yes, ma'am. They do the random drug screening once a week, and we get a therapy session with a counselor also throughout the week.
How do you do your random drug screen?
They send an Uber and bring me to Quest on 9th Avenue. So
Have you already done one of those?
I have one set up for tomorrow.
Okay.
Yeah.
Where do you work?
There you go.
With Bechtel, Environmental Safety and Health Representative with Bechtel. For our LNG.
So how would you get to and from work and things like that if you're not going to drive?
Yeah, my nephew also works out there, same shift, so I can ride with him.
Just for the record, I am reviewing the court's file, and part of that does include the probable cause affidavit for the new driving while intoxicated. I was looking to see, but I don't know that it's.
It's not yet been received, Your Honor. Testing has not yet been completed.
I was trying to also see, do you have a copy of that previous pre-sentence report?
I had it on my computer earlier, Your Honor, to pull it back up.
Ours didn't, because it's an older case, it's not in here.
Just when it seemed sympathy might win the day, the judge discovered something that completely changed the equation.
Okay, please, ma'am. I guess an issue that I have that we're going to have to talk about. So Mr. Roberts signed a no driving agreement with probation March 19th. And then
This is exactly why judges take probation violations so seriously. A signed agreement isn't just paperwork, it's a promise to the court.
the allegations are that a month and a week after when this happened, he was driving. So he'd already told someone and signed an actual document saying he wasn't going to drive. So obviously the argument of I'm not going to drive gives me some concern because you already have been there, done that.
How many set of keys do you own?
Man.
No, to your
No,
car.
I have one, my wife have one.
For the same car?
Yes, sir.
We'd be willing to turn over both sets of keys.
Wasn't driving his car on this date.
Fair enough, Judge.
So I'm not saying I'm not going to set it a bond, but these are the concerns that obviously there was something going on that I'm not quite sure about, but obviously there was something going on for there to be a no motor vehicle drive form
Yes, ma'am.
signed a month before. So there were some concerns already.
I have previous PSI. for
Sounds like it's coming as well over here. Thank you, Mr. Nichols.
Take it.
Mr. Nichols, what's your position?
Judge, I'd reviewed Ms. Molfino's email correspondence with the court and with Mr. Nix talking about her position on this case. We are not opposed to a reasonable bond being set. Obviously, we have concerns, same as the court with the driving. I believe a scram will take care of any concerns about substance abuse, but there's just not an easy way to be completely certain about the driving. Given the circumstances, given his willingness to do what he's already done and what he's going through, that's why the state does agree for a reasonable bond in this case, Your Honor.
Okay, so
That wasn't just a warning, it was a deadline for change. In courtroom language, make it or break it means the next mistake could cost years of freedom.
Mr. Roberts, I want to make sure you understand, I'm going to set a bond, and if you make that bond, there will be some very specific conditions. Some of those conditions are conditions you already have on the probation. At this point, I understand that you're going through something very traumatic in your life, which tends to lead for people who have substance abuse or alcohol issues for those to get worse. If you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond. Do you understand?
Yes, ma'am.
So what I'm going to do is grant the motion to set a bond in cause number 20-34226. I'm going to set the bond at $25,000. I am going to order as a condition of that bond that you wear a scram device at all times. If there is a positive alcohol screening, I will know about it. There will be a warrant. There will be no bond, and we'll be looking at that 7 years. It's that simple. Also, as a condition of that bond, you are not to drive any vehicle ever. Period, under any circumstance. If you're with people and they're drinking, then you're not the one that drives. Y'all walk, y'all get an Uber, you do something else. You understand? Also, I am going to order as a condition of your bond that you, and really I want it to be a condition of probation as well, to modify your conditions of the probation you're currently on, to order that you can continue that program, the IOP, through Trust Health. I want proof of that, verification of that sent to your probation officer each week or whatever you can do. If it's online, you should be able to print something out to send to them to show that you're doing the 3-hour meetings, as well as any drug or alcohol screen that you get done. You need to get those results also to your probation officer. Okay.
Yes, ma'am.
So that'll be a condition of bond as well as your probation. Any other conditions that I didn't cover?
Those are the ones that I was concerned about. I think that'll cover it.
Okay. All right. So what we'll do, if you make that bond, you'll have another court date set. Stay in touch with Mr. Nick. He'll let you know when you need to be back here and in court. And again, whatever you need to take care of to keep yourself doing the right thing, going through what you're going through, you need to make sure and get that done, because being in prison won't help the rest of your family. Okay. All right.
Thank you, Judge.
Yes, sir. I'll shoot a message over. to
Thank you. I
Townsend.
appreciate it.
What do you think? Did the judge strike the perfect balance between accountability and compassion? Or was this already one chance too many?